Good morning, everyone. Good morning, participant. Today, Saturday morning, we have a very special honor guest, professor, giving us public lecture. So we have Professor Muhammad Ekramul Haq from Dhaka, Bangladesh, Dhaka University, Bangladesh. So Professor Muhammad Ekramul Haq is a professor from the Department of Law and the coordinator of Law Clinical Legal Education Program at the University of Dhaka, Bangladesh. So today, Professor Ekram will give us public lecture on impact of comparative constitutional law on the liberalization of Locus Standi, constitutional transplant of public interest litigation in Bangladesh. So before Professor Ekram will deliver his lecture, we have Dr. Radian Salman as the head of the program for Law and Development at our postgraduate school. Dr. Radian Salman will give a few words before Professor Ekram's lecture. Please, Dr. Radian Salman.
Thank you, Dr. Rosa. Assalamualaikum warahmatullahi wabarakatuh. Professor Ekram, good morning. I know this is weekend, Saturday, and therefore I would like to express my gratitude to you, Professor Ekram. Thank you for your willingness to give a lecture to my student and also a fellow of school, postgraduate school, Airlangga University. Once again, it is an honor for us to have you as one of our visiting lecturer. I believe that our topic today is a very interesting topic. Like in Indonesia, that judicial review in constitutional court is always an interesting issue. But you may will share about the specific issue concerning constitutional transplant of public interest litigation, which is in Indonesia, this is not so clear. Even, for example, if you are an NGO, then you may stand before the court on behalf of the public to litigate on constitutional issue. Without further ado, once again, I would like to thanks to Professor Ekram for your time, for your willingness to give lecture in this morning. Thank you.
Okay, thank you. So without further ado, I would like to invite Professor Ekram to deliver his lecture. Please, Professor Ekram.
Thank you so much, Dr. Rosa and Dr. Salman. At the very outset of my lecture, I'm expressing my deepest gratitude to Universitas Airlangga, one of the oldest and well-reputed universities of Indonesia, for inviting me to deliver this international public lecture. And greetings from Bangladesh and the University of Dhaka, where I'm working as a professor of constitutional law and comparative constitutional law. Well, I think it will be useful for all of us to have a very brief introduction about the legal system and constitution of Bangladesh at the very outset of my lecture. Well, Bangladesh was established as an independent and sovereign People's Republic of Bangladesh on 26th of March, 1971, through making a unilateral declaration of independence, which is a very popular theme of public international law. And this particular UDI was, in fact, the first successful UDI in a non-colonial setup in the entire world. Well, the current constitution of Bangladesh was adopted back in 1972, which is completing almost 50 years. So we're proud of this constitution because we are going to complete 50 years. And this is an autochthonous constitution. Nationalism, socialism, democracy, and secularism are four fundamental principles of the constitution and of the state policy as well. And constitutional model of protection of human rights in Bangladesh can be compared to International Bill of Rights, which is composed of the Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, and International Covenant on Economic, Social, and Cultural Rights. So just like the UDHR, the Constitution of Bangladesh has generally recognized all types of human rights, but at the same time, it has split human rights into two different categories following International Bill of Rights model. One group of human rights have been recognized as judicially guaranteed rights in the Constitution, while another group does not have any sort of enforcement mechanism, and they are not judicially enforceable. The Constitution has expressly said that civil and political rights are judicially guaranteed, while economic, social, and cultural rights are not judicially enforceable. Well, Bangladesh is a unitary state, and it has a single highest court, superior court, that is known as the Supreme Court of Bangladesh. And unlike Indonesia, we do not have any separate constitutional court. And I understand that establishment of a separate constitutional court is always good for the application of constitutional provisions in a country. And we sometimes also discuss in Bangladesh about the possibility of establishment of a constitutional court in Indonesia or in the model of many other countries in the world. And while I attended the third international symposium organized by Indonesian Constitutional Court back in 2019, we had a very interesting discussion on the establishment of a court like Constitutional Court of Indonesia in Bangladesh. Anyway, we don't have currently any such constitutional court, and the Supreme Court of Bangladesh, that has every jurisdiction regarding all constitutional matters. And judicial review is a very important constitutional remedy in Bangladesh, just like Indonesia, as Professor Dr. Salman was telling about, that judicial review is also a very important remedy in Indonesia as well. So in Bangladesh is the same scenario. However, I need to clarify one thing, that I'm going to discuss about the influence of comparative constitutional law on the development of the idea of liberalization of Locus Standi and the eventual establishment of public interest litigation in Bangladesh. And that's why I feel it essential to give a very brief theoretical framework of using foreign judgments in Bangladesh, because eventually I'm going to discuss on the influence of comparative constitutional law. It's not going to be an exhaustive lecture on how public interest litigation is operating in Bangladesh. Rather, I'd like to show the influence of comparative constitutional law on the liberalization of Locus Standi. Well, very briefly, the theoretical framework. The thing is that despite the fact that the Constitution of Bangladesh is an autochthonous constitution, of course, there are a number of instances of constitutional transference of different foreign ideas in Bangladesh. And interestingly, it has never been controversial in Bangladesh to use foreign judgments in interpreting and establishing different constitutional ideas. And perhaps Bangladesh, as a new member comparatively in the international legal community, has a long tradition since its birth of taking aid from foreign judgments, perhaps in order to provide legal interpretations and to make sure that the legal developments are made in conformity with the global standard. The judges in Bangladesh, in fact, extensively use, I'm telling you, extensively use foreign judgments in constitutional law cases. However, in spite of such an extensive use of foreign judgments, Bangladesh actually lacks any particular theoretical framework regarding the use of comparative constitutional law. And as such, it lacks discussion on different theories of comparative constitutional law, like functionalism, expressivism, or contextualism, or even the recentmost theory advocated by Professor Mark Tashnir, which is known as the theory of bricolage. Although it is true that the Supreme Court does not make any sort of discussion regarding the theoretical aspects of comparative constitutional law, in my opinion, that, in my opinion, in adopting different constitutional judgments from different foreign countries, Bangladesh has in fact adopted the theory of bricolage. We know about the theory of bricolage that has been advocated by Professor Mark Tashnet, as I have said already, that unlike functionalism or expressivism, because for functionalism, you need to show that this particular idea, if it is taken from, for example, we want to take something from Indonesia, then we need to show that it will perform the same function in Bangladesh, whatever is being performed in Indonesia. Or for the adoption of a comparative constitutional idea through the theory of expressivism, we need to prove that the same result we'll get in our country if we adopt something from a foreign judgment. And in order to avoid the evils of both functionalism and expressivism, Professor Mark Tashnet argued for bricolage, because bricolage is something that allows a country to take something in support of its own constitutional interpretation. So without going through the complexities of functionalism or expressivism, bricolage is an ideal theory of comparative constitutional, in my opinion. And whatever the judges are actually doing in practice in Bangladesh, they're doing nothing but they are adopting the theory of bricolage. Well, let me now come to the point of my today's lecture, that how has the concept of Locus Standi been liberalized in Bangladesh and eventually has opened the door of public interest litigation? Because we all know that Locus Standi is something that says that someone, before coming to the court, has to prove that that person is an aggrieved person. So he has been suffering from a direct injury of one of his constitutional rights. Well, if Locus Standi is generally construed from this particular perspective, then public interest litigation will be impossible altogether. Because for allowing public interest litigation, you actually need to relax, liberalize the rigid construction of Locus Standi. That means you need to allow someone, even if that particular person is not directly an aggrieved person, to come before the court, to raise an issue of public interest. But so long the rigid construction of Locus Standi will be there will be no such possibility of allowing public interest litigation through the application of the doctrine of judicial review. So what about the idea of Locus Standi in Bangladesh? In fact, back in 1972, Bangladesh adopted its constitution and adopted the British model of the concept of Locus Standi. We all know generally, as the students of comparative constitutional law, that the idea of Locus Standi was developed in England very rigidly, because the classical British constitutional law did not allow anyone to come before the court unless he or she could prove an actual and genuine loss of his or her own right. So naturally, since that particular concept was textually adapted in our constitution, so in 1972, in the light of then British development, there was no such scope for public interest litigation in Bangladesh back in 1972. Well, let me clarify something about the scope of my lecture, because there are a lot of cases, and I'm not going to refer hundreds of cases in my lecture in order to confuse my listeners. Rather, I would like to make a focused discussion, taking basically two cases. Why? Because this is not going to be an exhaustive lecture, either on Locus Standi or public interest litigation generally. It is very focused lecture from comparative constitutional law perspective only. Well, Article 102 of the Constitution has actually used the term aggrieved person, who can actually raise a case for enforcement of any constitutional right before the Supreme Court. The definition and periphery of Locus Standi have interestingly, subsequently been explained and developed by the Supreme Court of Bangladesh. And the first case of liberalization of Locus Standi, is Qazi Mukhlis case. Qazi Mukhlis case, which was decided back in 1974, just after 2 years of the adoption of the Constitution. So it is good to see that Bangladesh started the liberalization of Locus Standi right after 2 years of the adoption of its own Constitution. However, the first case of liberalization of Locus Standi that eventually clearly established the concept of public interest litigation in Bangladesh was not Qazi Mukhlis. That was Mohiuddin Farooq case, which was decided on 25 July 1996. So look at the development, that the origin lies in Qazi Mukhlis in 1974, but the real development that actually opened the door of public interest litigation and established the idea of PIL firmly, that was done in 1996. So it took 22 years, not for all the way for the development actually. And the jurists in Bangladesh generally think that it took 22 years for clear establishment of the idea of PIL because of chiefly Bangladesh has gone through some martial law regime during that particular time that actually created as an obstacle in the way of real development of public interest litigation. Well, it appears that Qazi Mukhlis case, where Locus Standi was expanded for the purpose of giving a remedy against possible violation of fundamental right, because Qazi Mukhlis actually challenged before the court a bilateral treaty between India and Bangladesh. And he argued before the court that, well, my lord, if that particular treaty takes place, then I will not be able to exercise my constitutional right to freedom of movement in that particular territory, which will eventually be given to India. Well, an involvement of grave constitutional law issue, that is the possible unconstitutionality of a bilateral treaty. Thus, in my opinion, although the concept of liberalization was rooted in Qazi Mukhlis case, which has been acknowledged in Mohiuddin Farooq case in 1996 as well, it is submitted that Mukhlis case can be said to be the first case of liberalization of Locus Standi in general, not for PIL. So we are going to actually classify the liberalization of Locus Standi into two groups: liberalization of Locus Standi generally and liberalization of Locus Standi for the purpose of public interest litigation. It is true that liberalization of Locus Standi for public interest litigation, of course, bears some significance of liberalization of Locus Standi generally as well. So the first one was done in Qazi Mukhlis case in 74, and the next one was done in Mohiuddin Farooq case in 1996. That's why, in order to examine the influence of comparative constitutional law on the liberalization of Locus Standi, opening the door for public interest litigation, I have mainly chosen these two cases. There are many other cases, of course, on the point of Locus Standi of liberalization, but they all have generally cited both Mukhlis and Mohiuddin as the origin of the concept. That's why I'm focusing on these two pioneer cases only. And apart from these two cases, I will discuss another case of Tayyib case to show the further development of the concept of liberalization of Locus Standi. That is briefly the periphery and scope of my lecture that I have made clear at the very outset of my lecture, because it's going to be a long lecture of 45 minutes, I understand. That's why I have provided this very brief description about the scope of my lecture at the beginning. Well, let us now come to the point. As I have already said that Article 102 of the Constitution of Bangladesh has said that an aggrieved person may apply before the court for getting a constitutional remedy, generally speaking. And that implies that only an aggrieved person can come before the court. So what happened back in 1974 in Qazi Mukhlis case? The facts in brief is that there were certain conclaves near to Bangladesh, but owned by India. You know that India is a neighboring country to Bangladesh. And there were certain other conclaves, a small part of the territory, attached with India, but owned by Bangladesh. So there was a treaty exchanging those conclaves. The conclaves owned by India, but situated near to Bangladesh, were handed over to Bangladesh and vice versa for the benefit of the people at large. Both the countries agreed. Then Mr. Mukhlisur Rahman challenged the validity of that particular treaty before the court, saying that his fundamental right will be infringed because he will not be able anymore to move on that particular territory that will eventually hand it over to India. And eventually that will violate the Constitution of Bangladesh. So he challenged the legality of that particular treaty before the Supreme Court of Bangladesh. Supreme Court has two divisions. One is the High Court division, another is the Appellate division. So a petition is initiated before the High Court division. And Mukhlisur Rahman went to the High Court division. And the High Court division summarily rejected the petition, saying that, who are you, Mr. Mukhlis? You are not an aggrieved person because you do not reside in that particular portion of the territory. So someone who lives in that particular territory, which is going to be handed over to India, may come before the court if he or she likes, but that is not you, Mr. Mukhlis. And summarily rejected the petition. Then Mr. Mukhlis appealed before the Appellate division. And it is the Appellate division of the Supreme Court which accepted the Locus Standi of Mr. Mukhlis. On which ground? On the ground that this is a case of violation of fundamental rights, possible violation, because he will not be able in future to move in that particular territory. And this involves a grave constitutional issue. So technically speaking, it was not a case involving public interest, because Mr. Mukhlis did not say before the court that, my lord, this is a case of public interest. Rather, he said it before the court that this is a case of infringement of my own fundamental right. Nevertheless, it paved the way eventually for opening the door for public interest litigation, because the Appellate division granted Locus Standi in favor of Mukhlis. Look, Qazi Mukhlis case has multi-dimensional facets. I'm not going to make any exhaustive discussion on all those multi-dimensional facets, but I'll be focusing only on how has the court liberalized the concept being influenced by comparative constitutional law. Well, in accepting the Locus Standi of Qazi Mukhlis, the Appellate division of the Supreme Court of Bangladesh was actually deeply influenced by comparative constitutional law. The court first said about an Indian case of Maganbhai Ishwarbhai Patel versus Union of India, which was decided back in 1969. That case was involving an arbitration between India and Pakistan. And someone challenge the validity of that particular arbitration award, which took place between India and Pakistan. But Indian Supreme Court did not grant Locus Standi in favor of that particular person. But in a similar type of case in 1974, after 5 years of that Indian decision, the Supreme Court has referred to this decision and said that unlike this Indian decision, we are actually granting Locus Standi in favor of Qazi Mukhlis. And in doing so, the Supreme Court of Bangladesh referred to a decision of Pakistan Supreme Court, which took place back in 1969. Chief Justice Hamodur Rahman in Fazaldin case said, rightly considered, sufficient interest for maintaining a proceeding in the nature of public interest. And Justice Hamodur Rahman said that for the purpose of filing a petition before the Supreme Court for enforcement of a constitutional right, someone does not need to be affected directly. And an infringement of a right in a strict juristic sense is not essential. Rather, it will be okay if someone can prove generally an infringement of a constitutional right. And generally the public are affected by that particular infringement of constitutional right. That will be sufficient. So Bangladesh court has referred to that particular Fazaldin case. And Bangladesh court also referred to a few American cases, Indian cases, and one Australian case as well. And then reached to the conclusion that, I'm quoting from the judgment, that it appears to us that the question of Locus Standi does not involve the court's jurisdiction to hear a person, but of the competency of the person to claim a hearing, so that the question is one of discretion, which the court exercises upon due consideration of the facts and circumstances of each case. So a very interesting principle was eventually adopted by the Supreme Court in Mukhlis case, that it is the competency of the person to raise the issue before the court. So one thing is that I'm becoming aggrieved directly. Another thing is that some other persons are being aggrieved by this particular activity of the state. And I am the person coming before the court, not because I have been directly affected, but I'm interested to raise the issue before the court. So raising an issue before the court is a concept that requires lesser degree of suffering. If you're directly, completely suffered, you are an aggrieved person. But I'm not asking for the remedy for myself. I'm coming before the court because I'm asking for the remedy for the public at large. So it may be so that I'm not as affected as other guys generally in the society. But that minimum level of suffering is sufficient to raise the issue before the court. And that concept was eventually adopted by Bangladesh court, that the competency to raise an issue before the court does not require a strict violation or a strict grievance on the part of the petitioner. Now the question is, was that an autochthonous idea, an innovative idea by the Supreme Court of Bangladesh? The answer is no. In fact, the court was deeply influenced by the then British law developments which took place in the United Kingdom. Here lies the crux of my lecture. I would like to show that at this modern time, the significance of comparative constitutional law has been greatly increased. And there are lots of cases of constitutional transplants in each and every case. For example, American constitutional law is, of course, one of the most ancient constitutional law systems in the world. But still, American constitutional law also is adapting something from comparative constitutional law from around the world. So this is not something unique for Bangladesh, that the constitutional court is being influenced by the comparative constitutional law. Well, let me look at the actual paragraph of the case where the court of Bangladesh had actually cited a British case, a Blackburn case. There are 4 famous Blackburn cases decided by the by the British court, and one particular Blackburn case was referred to by the Supreme Court of Bangladesh as the basis of its new interpretation of relaxing Locus Standi. Well, Blackburn was a case involving a treaty, namely the Treaty of Rome, and someone challenged the validity of that particular case. And Lord Denning said that that is not a matter which you need to rule upon today. He says that he feels very strongly, and that it is a matter in which many persons in this country are concerned. I would not myself rule him out on the ground that he has no standing. So that Mr. Blackburn challenged the validity of a treaty. And Lord Denning said that it is true that he was not personally aggrieved. But if the treaty takes place, that will affect the interest of the public at large. So I'm not going to investigate into the matter whether Blackburn was personally interested in that particular case or not. And as such, the Locus Standi was relaxed in that particular Blackburn case. And these actually form the basis of Mukhlis case of relaxing the idea of Locus Standi. So what is the conclusion? Conclusion about the Mukhlis case is that Qazi Mukhlis case was actually influenced by British idea of relaxing Locus Standi. Now look at the interesting aspect of this particular involvement of British law in the development of Bangladeshi constitutional law, that the original constitutional provision was influenced by the then British development. I mean, strict construction of Locus Standi. And the later judicial development was also equally influenced by the British development, British judicial development that took place in Blackburn case. Well, then after Qazi Mukhlis case, 22 years elapsed. And the concept of liberalization of Locus Standi came later on the board in 1996 in Muhyiddin Farooq case, which is going to be the crux of my lecture, because it is the case that was decided in 96 that actually opened the door for public interest litigation. Well, the facts in brief of this particular case is that one flood action program, a project was undertaken by the government in one particular district, but Dr. Muhyiddin Farooq did not reside in that particular district. He used to live in the capital city. Nevertheless, he challenged the legality of that particular action of the government. According to the opinion of Dr. Muhyiddin Farooq, if that project is implemented, that will affect badly the interest of the farmers in that particular locality, because that will prevent, of course, flood, but at the same time, that will create problems regarding irrigation because of constraints to the access to enough water to have the irrigation properly. And eventually, the people of that particular district will fail to earn their livelihood. So Dr. Muhyiddin Farooq challenged the validity of that government action. and argued before the High Court Division to declare that government project null and void. Then the High Court Division asked Dr. Mohiuddin Farooq, Mr. Farooq, do you reside in that particular district? Farooq said no. Then the court said, Mr. Farooq, you are not a person aggrieved. So how could you file this petition before the court? And the petition was summarily rejected by the High Court Division. And then Mr. Farooq appealed to the Appellate Division. And the Appellate Division granted Locus Standi in his favor. Before the Appellate Division, Dr. Farooq said, my lord, I'm not an aggrieved person, but my heart bleeds for those unfortunate people who are going to be affected by this project of the government. So I am here before the court, my lord, to protect the interests of the public at large, not of myself, not of my personal interest. And the court accepted it. And the court construed the meaning of the phrase aggrieved person liberally, and as such relaxed the rigid idea of Locus Standi. That actually opened the door for public interest litigation in Bangladesh. Because once that decision was made, then thousands of decisions, thousands of cases were filed before the Supreme Court regarding public interest, regarding the protection of the river, regarding the protection of the environment, regarding the protection of the health of the people, and so on. That Mohiuddin Farooq, in fact, opened the door for public interest litigation. Now, I'm going to show you one thing, that apart from textual interpretation, in reaching to the conclusion in Mohiuddin case, the Supreme Court of Bangladesh was influenced by comparative constitutional law materials. There was an influence, a deep influence of Indian jurisdiction, because Indian constitutional law had been much more developed by that time. You know that Bangladesh was ahead of India while Qazi Mukhlis was decided back in 1974. At that time, Bangladesh was ahead of India in terms of relaxing the idea of Locus Standi. But after that decision, Bangladesh gone through a barren period. And during that time, India became much more development in relaxing the concept of Locus Standi. And as such, later, in 1996, Bangladesh was influenced by Indian development made in that particular area. Well, Justice Mustafa Kamal was the author judge in Mohiuddin Farooq case, and he has referred to S.P. Gupta case decided by the Indian Supreme Court back in 1981, and it was reported in 1982. That particular S.P. Gupta case made an elaborate discussion on the point of sufficient interest. It was said in S.P. Gupta case, what is sufficient interest to give standing to a member of the public would have to be determined by the court in each individual case. It has necessarily to be left to the discretion of the court. The reason is that in a modern complex society, which is seeking to bring about transformation of its social and economic structure and trying to reach social justice to the vulnerable section of the people by creating new social, collective, diffuse rights and interests, imposing new public duties on the state and other public authorities, infinity number of situations are bound to arise, which cannot be imprisoned in a rigid mold formula. The judge who has the correct social perspective and who is on the same wavelength as the Constitution will be able to decide without any difficulty and in consonance with the constitutional objectives whether a member of the public moving the court in a particular case has sufficient interest to initiate the action. This particular paragraph from S.P. Gupta was cited by Justice Mustafa Kamal in Muhyiddin Farooq case in order to distinguish between interest and sufficient interest. So as I said it at the beginning of my lecture, that Bangladesh court distinguished between interest and sufficient interest. This is a very interesting point, that if you are a person who has been directly affected by that particular action of the government, you have the interest. I may not be directly affected person, but I'm raising the issue involving the interest of the public at large, and that will be deemed to be sufficient interest. And in Muhyiddin Farooq case, that the court said that Mr. Muhyiddin Farooq had sufficient interest, though not interest in its strict sense. And in doing so, the court was influenced by S.P. Gupta case. Well, Justice Mustafa Kamal, in fact, traveled all around the world of comparative constitutional law in giving this particular decision. This is a case of extensive influence of comparative constitutional law. He cited something from United States of America, something from India, from Sri Lanka, and from the United Kingdom as well. Well, I'm quoting a few paragraphs from Justice Mustafa Kamal's judgment. He said that in his report on legal services, the Rajasthan Law Reform Committee observed that public interest litigation can prove to be the glory of our legal and judicial system if it is cautiously and sparingly used after careful study and research. Then he has cited to Justice Krishnayar, one of the famous Indian judges, who suggested for the formation of lawyers' cooperatives who will take up the cases of public interest. He cited it in Muhyiddin Farooq case. Then he said that, like the United States, these cases are also called public interest litigation. But in India, the jurisprudence has extended to procedure as well, treating even a letter as a writ petition. So Indian court treated even a letter to be sufficient as a petition before the court. And our court has referred to that particular Indian development. And then about Sri Lanka, the Supreme Court said that in Sri Lankan constitution, in the then constitution, there was a textual problem. Due to the existence of a rigid text in the constitution, no one could come before the court taking an issue involving a public interest. But later, that was relaxed by Sri Lankan court. That was relaxed by Sri Lankan court. And what happened in Pakistan? In Benazir Bhutto versus Federation of Pakistan case back in 1988, it was held that a person can come before the court involving an issue of public interest. Justice Mustafa Kamal has cited to all these cases. Then he concluded that if a person raises a purely individual cause, he is a person aggrieved if his own interests are affected. But if he raises a public cause involving public wrong or public injury, he need not be personally affected. And he concluded that this particular new judicial interpretation is actually in line with the developments of liberalization of Locus Standi that has taken place worldwide. And as such, the global constitutional law gene pool played a significant role in the development of that particular idea in Bangladesh. Another judge in that particular case, Justice A.T.M. Afzal, cited to an American case, Sierra Club versus Morton, decided back in 1971. In that particular case, the American court said that contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own preservation. What a fantastic concept initiated by American Supreme Court, that even a tree should be given the standing. Even a river should be given a standing. And you know that in Bangladesh recently, there has been a judgment regarding a river which said that river is a legal person, as good as a human being. Every river holds constitutional rights just like a natural person. Well, Justice Latifur Rahman, another judge in that particular Mohiuddin case, made a very interesting comparative constitutional law analysis. He said that if you look at the text of the Indian Constitution, then in Indian Constitution, it has not been explicitly mentioned that an aggrieved person will come before the court. Rather, it is generally mentioned that for infringement of a constitutional right, a person will come before the court. And thus, he has shown that the text in the Constitution of Bangladesh is more favorable to relax the idea of Locus Standi. And as such, we see that what happened in Bangladesh, that comparative constitutional law materials have been used in different ways. For example, Justice Latif has used this particular comparative constitutional law material from a negative perspective, not in order to take something from another jurisdiction, rather in order to avoid something from another jurisdiction. That rigid construction of Locus Standi in that jurisdiction cannot be applied in this jurisdiction because our text is different than that particular jurisdiction. Well, then there is an interesting statement made by Justice Latifur Rahman in Mohiuddin Farooq case that he termed American constitutional law as the laboratory for the constitutions of the world. A laboratory for the constitutions of the world. Because we all know that there are many constitutional concepts which have been imported from United States of America by the constitutional jurisdictions around the world. And even Justice Latif has mentioned it categorically that the idea of Locus Standi, liberalization of Locus Standi, and as such to allow the class action took place in America before England in 19th century. This particular concept was highlighted by Justice Latif, that the idea of accepting public interest litigation developed in 19th century in the United States of America. And later, in 20th century, British courts have actually relaxed Locus Standi in order to allow public interest litigation. And in the United States of America, as has been said by Bangladeshi court, it is known as social action litigation. And that term, social action litigation, was eventually accepted in India as well by constitutional judgment pronounced by Justice Krishna Iyer. And there is an interesting term which is known as epistolary jurisdiction. Epistolary jurisdiction. This is a jurisdiction of the court to allow a person, if he comes before the court with an issue of public interest. It did not exist in our legal literature before Mohiuddin Farooq case. It came into being through Mohiuddin Farooq case under the influence of American, British, and Indian jurisdiction. And later, in 2012, it got a statutory recognition in the Supreme Court rules adopted by the Supreme Court that says that the High Court Division has the epistolary jurisdiction. That means even if someone cannot come before the court, who is an aggrieved person, the court can accept any sort of information as a valid ground for initiating the legal proceeding. Well, I'm not going through the judgment a lot. I'm just coming to an end, showing the later development of that particular liberalization of Locus Standi. So let me make the summary. So far, I have discussed here. Phase 1, 1972 Constitution, original text, rigid construction of Locus Standi. Phase 2, 1974 Mukhlis case, liberalization of Locus Standi generally. Phase 3, 1996 Muhyiddin Farooq case, liberalization of Locus Standi for the purpose of allowing public interest litigation. That actually was influenced deeply by comparative constitutional law. And what next? The next thing happened in Tayyip case in 2000. Tayyip case is a very interesting case because in that case, no one applied before the court, unlike Muhyiddin Farooq case. Because in Muhyiddin Farooq case, Muhyiddin Farooq came before the court. But in Tayyip case, no one came before the court. The High Court Division started the proceeding by its own, which is known as suo motu PIL. Certain constitutional rights of a poor Shahida Begum were infringed because of declaration of an illegal fatwa by the local village leaders going against the law and against the Sharia as well. And for that particular victim, no one came before the court. And this particular news was published in a newspaper, and going through the newspaper, the judge started the proceedings before the court as a public interest litigation. So this is the extreme development of liberalization of Locus Standi. What happened in 1996 that has taken an extreme position in Tayyip case because of suo motu, the start of the legal proceeding. And the court has referred to Marbury versus Madison, a famous American case. I'm almost at the end of the time, so I'm just concluding very briefly. In Marbury versus Madison, Mr. Marbury came before the American court to have the job of the judge. And he came before the court under the Judiciary Act of 1789. But the court eventually declared that particular law to be null and void, under which he filed a petition before the court. The question is, who petitioned before the American Supreme Court for declaration of nullity of the Judiciary Act of 1789? The answer is no one. No one petitioned it. The court declared that law to be null and void by its own. Referring to that particular case, Marbury versus Madison, the Honorable Chief Justice of the Supreme Court, Honorable Chief Justice of Bangladesh, has reached to the conclusion in Tayyip case that the court in appropriate cases can even move suo motu. And this is the extreme development of public interest litigation in Bangladesh, which was also influenced by comparative constitutional law. And at the end, I'd like to mention one thing, that from theoretical perspective, in my opinion, what has happened in Bangladesh regarding the use of foreign judgments in the development of its constitutional law is nothing but the adoption of the theory of bricolage, unlike expressivism or functionalism. This is nothing but the application of bricolage, which says that you can utilize available judgments from foreign jurisdictions whenever you feel necessary to establish an idea in your own constitutional law. That's all from me. And I'm again thankful to the Universitas Airlangga for inviting me to be a lecturer in this particular session on international public lecture on comparative constitutional law. Especially, thank you very much, Fitri, for making all administrative arrangements for me. Thank you very much, Dr. Rosa and Dr. Salman. Thank you. If there is any question from the audience, I'd love to give answer.
Thank you, Professor Ekram, for your lecture in the issue of Locus Standi for public interest litigation, especially, of course, in Bangladesh with a comparative perspective. Now, I would like to invite all participants. You may have a question or issue that you would like to discuss with Professor Ekram. Of course, it is not necessary to discuss about a specific case in Bangladesh for participants, but you may have any issue that you may compare to Indonesian context in the issue of Locus Standi in yes, as Professor Ekram already knows that we have a separate court, constitutional court and Supreme Court. So anyone, if you have a question, you may raise your hand and directly to speak in the Zoom, or you may chat in chat provided in Zoom. Please, anyone, you may have a question. We still wait for all participants. If you have a question or an issue that you would like to discuss, please. Or Dr. Rosa, I know that you are a lecturer of constitutional comparative law, comparative constitutional law. You may have any question or comment, please.
Okay, thank you. Maybe I will start with giving a gratitude for Professor Ekram for a great lecture today, which actually relevant to what we have yesterday with Professor Richard Albert. So actually, what you discuss today, Professor Ekram, is one of the example of country experience. So at this context is Bangladesh experience with the global value and what you call it as a liberalization. Well, I just want to ask you about your perspective in this case, about the global value and what you call it as a liberalization in the Constitution. And in this case, maybe you may refer to the judicial mandatory. Maybe in well, yesterday we have a lecture that, and we know that, for example, like South Africa, which the Constitution put mandatory for the judicial to refer to the international law, which means that the global value maybe, Well, in the context of Bangladesh, I would like to know your perspective. Is it like a good for the Constitution in Bangladesh and the judicial branch at this context? If Bangladesh refer to the foreign law, what you call it as a foreign law, adapting foreign law in the judicial system, maybe, So is it like a good for the constitutional system in Bangladesh, or maybe it will like decreasing the local value of constitution for Bangladesh? What do you think about that?
Well, Dr. Ruda, you have raised a very important issue of comparative constitutional law and comparative law as a general. The thing is that I'd like to quote Dr. D.D. Boshu, who said that, who asked a question that, well, is this possible at this age to write a completely new constitution, an innovative constitution? Then he has replied in negative that it is not possible. Why? Because all good things have already been written. So if you really write one constitution, all provisions are completely new that do not exist anywhere in the world, then someone has to understand that you must have written something that is not good. Well, so borrowing from different constitutional laws around the world is a common phenomenon. And you know that using foreign judgments is a controversial issue in certain constitutional jurisdictions. For example, if you come to one of the most ancient constitutional law systems of the world, there is the American constitutional law system. In American constitutional law jurisprudence, we see that there is a debate regarding the use of foreign judgments by American Supreme Court. There are two different opinions. One favors the acceptance of foreign judgments to develop its own ideas. Another group of judges, they think that if we use foreign materials or even international principles in the development of our own constitutional law, that will destroy our inherent nature of the constitutional law. That is, destroy our homogeneity, our autochthonous nature of the constitutional law. But in Bangladesh, unlike this particular debate in America, in Bangladesh, we do not have any such controversy that exists. And you know that the comparative constitutional lawyers around the world nowadays strongly feel borrowing of the ideas from one jurisdiction to another jurisdiction. As I said, that public interest litigation is an idea in Bangladesh that has actually been borrowed from America, England, and India. And we have our own developments made in this regard as well. For example, Bangladesh is now thinking about the establishment of a separate constitutional court. And in doing so, of course, we can utilize the experience of Indonesia. So that is the beauty of comparative constitutional law. And let me share an experience with you that at the time of the third international symposium organized by Indonesian Constitutional Court that I attended along with my Chief Justice from Bangladesh in Indonesia. And we had a very interesting chat with the people of Constitutional Court of Indonesia and our Chief Justice regarding the possibility of establishment of a separate constitutional court. That what are the advantages of establishment of a separate constitutional court? So this is just an example I'm giving you. The main point that I'd like to focus is that comparative constitutional law can be used as a very effective tool for the development of the constitutional laws around the world, because we are now living in a global village, and interaction between the states are increasing day by day. And as such, we can develop each and every constitutional system and legal system side by side. Thank you so much, Dr. Rosa.
Thank you so much.
Is there still anyone who would like to raise issue from this lecture? Please, if you want to speak directly, please. If you want to write in chat box, please. Okay, Professor Ekram, I have two issues from your lecture. Yeah. First, that my issue is actually reflecting from the development of Locus Standi in Indonesian Constitutional Court, when I see that at the first phase of our Constitutional Court, I mean by our first phase is at least 5 years after establishment of the court, I see that the court liberalized Locus Standi. So one of the decision that I still remember is the judge says that every taxpayer has a right to submit petition in the Constitutional Court. But then I see that now, at least in my observation during these 5 years, the Constitutional Court make a limitation or stricter in the issue of locus standi. Then my question is concerning the Bangladesh, or you may give us a perspective from a comparison. How can you answer that the court, Supreme Court on Constitutional Court, not to be a rubbish bin if a court liberalize locus standi? That's first issue. Yeah.
Thank you so much, Dr. Salman.
Yeah.
It's a very interesting question and very pertinent question as well. I appreciate the question because while this particular concept came into the mind of the judges that we can relax the concept of locus standi, at that same time, that question arose before the court that, my lord, what will happen when millions of people will be coming to the court without having any sort of grievance? So the court will turn into, as you have said, turn into a bin of lots of things, waste matters. So how will the court deal with all those things? Yes. Just like Indonesia, Bangladeshi Supreme Court has also addressed that particular issue. In fact, back in 1996, this question was raised by the government side that, my lord, if you start allowing this particular idea of relaxing locus standi, and as such allowing everyone to come before the court, it will open the floodgate for everyone, and it will destroy the business of the court even. So what will happen then? Then the court specifically said that it will depend on the wisdom of the court. Which particular petition will be allowed and which particular petition will be rejected. However, we have many instances of many silly ideas to come before the court. In some of those cases, the Supreme Court rejected the petitions summarily in those public interest litigation cases. And later, there is an interesting development that took place in Bangladesh. That is the case of Abu Said versus National Board of Revenue. In that particular case, finally, the court has set up parameters for public interest litigation. The court has fixed now a specific guideline that which particular types of litigations shall be considered to be public interest litigation and which are not, which should be accepted and which should not be accepted. One former Chief Justice, he was then the Chief Justice of Bangladesh, Mr. Surendra Kumar Sinha, he in fact formulated that particular policy. In that particular case, it was clearly said that no petition, I'm reading from that judgment, no petitions will be entertained challenging the policy matters of the government, development works being implemented by the government, orders of promotion of or transfer of public servants, imposition of taxes by the competent authority. And the court has no power to entertain a petition which trespasses into the areas which are reserved to the executive and legislative by the Constitution. So one of the interesting parts of this particular case is that apart from setting the parameters of public interest litigation, at the same time, it adopted a constrictive approach. And so some people, some activist lawyers in Bangladesh, they are now in fear of being rejected by the court in the name of that particular scrutiny. Because the court has said that if the court thinks that something does not fall within judicial jurisdiction, but within the executive jurisdiction solely, that cannot be raised before the court. And you understand, I know that there are similar types of issues in Indonesia as well. There are a lot of executive actions that can be challenged before the court. And if you challenge the particular executive action before the court, can the court create a barrier in the name of the application of the doctrine of separation of power? The fact that cannot be denied that if an executive becomes lethargic in one particular country, then the periphery of judiciary will be wider, essentially, eventually. Yeah. Thank you, Salman.
Okay, thank you, Professor Ekram. One more second is from me is that the top liberalization of Locus Standi is, let me say, as a result of legal transplantation. As you already mentioned, this is from India, from United States, from British. Yeah. My question is, how judges say that it is taken or inspired from other jurisdiction? I mean that in the decision itself, is it does a judge side decision from other jurisdiction, or judges just interpret without citing directly from other jurisdiction? So my question is about method of writing, and then we can conclude that this is a legal transplantation.
Thank you, Dr. Salman. It's a very significant question that what about the theoretical framework of the application of foreign judgments in one particular country? And as I have said already, that Bangladesh Supreme Court has not developed any theoretical framework in adopting foreign judgments, which is a dangerous one. Because jurisprudence is the heart of every law. So even for the purpose of application of foreign judgments in constitutional law materials, you need to develop a particular theoretical framework. And I'm telling you one thing, I'm sharing one of my experiences that currently I'm working in a project on the use of foreign judgments, by different courts. In the International Association of Constitutional Lawyers, IACL. I'm sure that you are aware of that particular association. So there is a one research group in that particular International Association of Constitutional Lawyers that work on the use of foreign judgments worldwide. Well, they have named the project as use of foreign judgments. It is interesting to note that the use of foreign judgments is a general term. And they have used the term intentionally, because sometimes we have seen that some jurisdictions refer to some foreign judgments without any cause at all. It is not necessary to have recourse to a foreign judgment, but still I'm referring to. Maybe something has been clearly established on the basis of the domestic decisions, still one particular judgment has been cited. It happens so. So there are many different types of uses, sometimes in order to establish an existing idea. Sometimes a foreign judgment in order to support an idea that I would like to develop in my own country. And sometimes there is a different type of constitutional transplant that takes place that even may go against established constitutionalism in that particular country. That is dangerous if that destroys the constitution of that particular country. But in Bangladesh, particularly, I can tell you that there are lots of constitutional transplants that have taken place. And as I said in my lecture, that following the theory of bricolage, instead of going through the complexities of functionalism or expressivism or contextualism, the judges generally, they have used foreign judgments, whatever they wanted to establish. And in most of the cases, somehow there is a link with the text. Unless there is a link with the constitutional text, you cannot go beyond your constitution in the name of adopting foreign judgments. So whatever has been adopted so far by Bangladeshi court, that has been done in line with the liberal interpretation of the constitutional text. I'm using the term liberal interpretation. So liberal interpretation is one of the tools that has been utilized by the court in order to prove the thing that the court is not going to transplant something which destroys the constitutional law of its own country. Thank you, Salman.
Okay, thank you. My last word is that legal transplant or constitutional transplant also actually part of judicial dialogue. Do you agree that?
Yes, yes, of course,
Okay.
of course. It is indeed.
Yeah.
It is indeed.
Yeah, thank you, Professor Ekram. Interesting topic.
And maybe Dr. Salman, as you have also lots of developers in Indonesia, sometimes maybe we can make a comparative study between Indonesia and Bangladesh, or there may be a global comparison, both from Bangladeshi and Indonesian legal perspectives with the global constitutional law as a whole.
Yeah, this year I have research on the topic of judicial dialogue. So maybe in the future, Universitas Airlangga and Dhaka University, of course, with Professor Ekram, we may have a collaborative research on the issue of a comparative constitutional law.
Surely, we'll be happy to.
Yeah, I will be happy about that. Yeah. So because I think times goes fast, I would like to say that this is interesting topic, Professor Ekram, because we provide our students with comparative perspective, actually, especially for constitutional law. So I hope that the lecture will inspire us or inspire fellow students to develop further perspective on comparative constitutional law.
Sorry, Professor Salman, for the interruption. Sorry,
okay.
Someone has asked one question in the chat box. I'm giving the answer very briefly.
Please.
Antonino has raised up one issue of regarding the language of the judgment, that in some countries judgment is pronounced in one language which may not be understood by the people of other language. So what is the case of Bangladesh? In Bangladesh, the judgments are generally pronounced in English. So that is common for all. That is common for all. So it is true that Bangla is the state language in Bangladesh, but the language of the judgments of the Supreme Court is English. And we do appreciate that, because that becomes easily accessible for all people generally, and for the comparative constitutional lawyers around the world as well. Thank you, Anthony. Sorry for the interruption, Professor Salman.
Thank you, Professor Ekram. It is not necessary for me to conclude anything because this is a public lecture. So thank you, Professor Ekram. Thank you, all participants, for attending this public lecture. I give back to Dr. Rosa to give a closing remark for this lecture. Please, Dr. Rosa.
Okay, so thank you so much once again to Professor Ekram and all the participants, including the digital team and Ms. Fitri, to make it happen this public lecture. It's really great to hear from Bangladesh experience, and we would like to hear again from you, Professor Ekram. Yeah, I hope that you still have your willingness to give a public lecture and share Bangladesh experience for us. So thank you so much. Stay safe, everyone. I would close this Zoom, and good afternoon right now here. Oh, not yet. Good morning.
Good morning.
Have a good day. And Assalamualaikum warahmatullahi wabarakatuh.